share screen. Okay, all right. So MTS, all right. Welcome to PowerPatent, and we have a very quick solution to generate first draft for you. You can proceed using the conventional patent application flow, like background and summary and detailed description. But most lawyers, they typically like to start with the claims. And so in your case, since you specialize in game software, I'm going to copy a set of claims from a aristocrat patent issue patent. So as you can see here, this thing really has an apparatus claim and method claim. And, so that's the claim. We can preview the claim tree if you want to verify and validate. So here you have a system claim, and you have a method claim, and then you have I guess a read computer claim. This is all that, right? And then you'll see later how you can edit the claim. But if you don't like the claim the way it is, you can go backward and you can edit them and redo this process. And so that's the way to, but we are assuming that when you paste them in, you as a lawyer already have a nice set of claims that you want. So all you do is you paste them in, you click on draft the invention, and it will generate roughly 25 to 30 pages of text based on the claims alone. And then after it's done, we'll paste through it, and then we're going to add diagrams, and then we can generate additional text based on the diagram. So it's taking a little time, but so that's kind of the process. And then we have diagnostic that will then run on the text to make sure that the claims are, satisfy the 112 issues and also, support issues. So here, based on the claim, it automatically picks out the title for you. You can put in a client name, in this case, aristocrat, and maybe matter 001. You can put in any tag you want, maybe gaming. So you can see here, it automatically generates a background for you. You can ask it to generate more by clicking the auto field, but I think, the background isn't all that critical. The summary, again, based on the claim, it will generate the summary for you. And then you can also ask it to generate advantages of the invention for you. Okay. Abstract, typically we just recycle the summary. So we restate the summary as the abstract. Yeah, so you'll see some slight differentiation from the abstract from the first paragraph of the summary, but it's essentially a restatement of the summary. Okay. Then when you click on next, it will ask you to add the image, the figures, and because most patents do require figures. So you certainly can add an image, and I'm just going to randomly pick, I don't know, this image. Maybe pick something better. Is there maybe this is a real patent image. And then you can also add a flowchart from the claim. So in the claims, we normally will pick a method claim, right? So, and you can edit the parameters of it, the size and the stepping. So right now it's stepping out at 1100, and you can change that. You can say the node is, let's say, oh, that's the font size. Is it? Let me see.
I think the next one is a node. It says node step prefix and node step.
Yeah. So you can start it at 400 and then step by 2 or by 4 if you want. Okay. And you'll see it here. It's reflected here. Right?
Oh, yeah, that's very helpful. I like that. It's very nice.
Yeah, you can edit them. So instead of, if you don't like registering, you can change it to register.
Okay, that doesn't change the claim, right? The claim is unchanged. Is the
it just copies the method claim as that and convert that into flowchart.
Okay, but your claim is not
add a custom right here.
Okay.
So you can add whatever flowcharts you like, right? And so that's an illustration of the flowchart process. So now we got figure 1 and figure 2. And let's say submit. Okay, so figure one, you notice here that we need to fill in the description. So of a gaming device, gaming hardware, let's say, and this is a gaming mm, of a gaming process. Okay. And let's look at the text that it generated, roughly around 73 paragraphs. Wow, that's a lot. So, but anyway, so illustrating the part list. So we just arbitrarily use a thing here, but what you can do is you can say, let's say this is figure one. So let's say 110, I don't know, roulette table. And 120, I don't know, spinning wheel. 130 of a dice, let's say. Okay. So now that you've annotated this figure, you can generate a text associated with the annotation. And this is how you do that. You pick a spot where you want that text to be generated. So here, let's say we're going to auto text, and we're going to auto text figure one, right? So it's generating text based on your part list. Huh? Okay, so it looks pretty decent. So I'll insert it. Okay. So well, there it is. So the dice is there.
Oh, it's there. Yeah, now it's there.
And so you notice it auto numbers for you. Yeah, basically. So that looks pretty decent. So then what we do is we select a boilerplate. You can select your own boilerplate or use your own text or just you can just pick any of the default boilerplate. Let's go to the more interesting part of the claims. In the claims, you can edit them and it will check, for antecedent basis support. So for example, the claims is the roulette game. It should be a roulette game. D competition. It should be A. So wow. So this is actually the claims from the issue patent, and it has antecedent.
They weren't always the best about that kind of stuff.
Oh, interesting. So you can drag and drop, and you can add child. So for example, here I can drag this to here, and now that it renumbers, right? So you can play with it. It's graphical claim drafting. Then the next interesting part is the diagnostic. So, everything looks to be consistent. The part list, here it is. The noun phrases that are detected from the text that's generated. So I think we're gonna, segregate this into noun phrases that are not in the claim to indicate unclaimed subject matter, and we're gonna show that in different color. And then it will check for means plus function and things like that. And for software, when you check on a software tag, it will also automatically insert in computer performance enhancement text into there.
Okay.
The
It does all of 112. So when you say US 112, it does for 112 A, B, and F. For your US code, does it look for all kinds of 112 issues?
Well, I'll tell you what it looks for. It looks for support in the claim, antecedent basis issue. It'll look for means plus function and functional claiming language because
so all of it. Okay.
Yeah. So it'll look for it'll detect all occurrences of means, and all references to that mean. So it'll show all the structures of the mean. Okay. You can share this with your after you're done, you can share this with your inventors for review, and so that's why we have the ADS and IDS, so they can download and upload it for you. That's really not difficult. And so the way you share that is up here. You can edit the collaborator list. You can add collaborator into it. So you can have your inventors review it after you're done. And before you have them share them, you may want to save you may want to save your version so you can revert in case you screw it up. Okay. You can also do an interactive text. So for example, you can just say, how is I don't know, describe uh, a casino gaming environment, um, gaming network architecture, let's say. Okay, it will generate that, and you can paste that in, and you can see that generated right now. So you can interactively play with that. The way some users have done is to so you can copy it and then go back in the description, and then you can just insert them in.
That is really clever. I like that. That's very clever. Oh,
Yeah,
that makes a yeah. Instead of doing it yourself, you can have that done for you.
exactly. That's the idea, making life easy. Finally, you can review it, and you know, you can edit them, but it'll show. Let me see the claims, the figures, the text. You can edit them, but so that's kind of the final review. And after, oh, and I forgot the diagnostic feature. There is a mode where you, if you've used, you know, it will run some diagnostics for you. So here we got, you know, figures, some reference lists. You got claim tree. You got noun phrases that apparently hadn't been claimed. And then the rest of the text, and some of this text here, you know, is meant for inventors to review. So it may be a little, the section here may be, you know, too elementary for patent lawyer, but so it'll basically enable the you know, somebody who isn't you know, an inventor, when they review it, they can run a diagnostic also and fix that before it gets back to you. And let me see what else. So that's great. And then you can, of course, export as a Word. And when you export it, it will ask you if you want to delete after you've exported. And so you can always delete it and then re-upload them. So so here, this is how you see it. It's generated. It's formatted so that you can use the Patent Center to upload this directly. It's compatible. And let's see how many pages it's generated. It's roughly about 40 pages. And so, yeah, if I were explaining this to you, you could do this in about a matter of 5 to 10 minutes.
That is very interesting. Wow, I like this. And do you have to be connected to the internet or anything like that to do this, or like so you can get the definitions? Like, remember you had the casino gaming environment. You have to be connected to Chat GPT, or
Yeah.
as long as I'm okay.
Well, it's not ChatGPT. GPT is a free system, so therefore you don't, you have confidentiality issues. It's an
Okay.
API. So we have an API with a terms and conditions with OpenAI, and
Okay.
we hear, you know, they indicate that in the information being used is not going to be fed back to the computer for, you know,
Okay.
i.e. it's confident, it's your information.
Okay.
So we do use OpenAI as our back end, but you know, on the front end we have a lot of patent specific structure, diagnostics, and things like that. And so, by the way, if you have a particular template that you want to use, you can certainly use that with our system. All you do is you upload the template as a Word document, and then your template then is the starting point from which everything else is inserted into it. So that's the way. Let's say a lot of people have a template for a computer invention. They have a figure one with a computer ROM RAM CPU, right? And then a standard description of a standard computer as your template for a software invention. You would take that template, upload them up, and everything else, it would fill into that template, and then you download it again.
Mm-hmm.
So that's how we can deal with template procedure. We are working in the few, we're still working on it. So here, you know, you can delete it if you want, right? So I guess I'll delete it. But here you will see that we don't talk much about it, but we have internal docketing capability where we can import direct connection into the patent office. So you know, so it brings the information from the old private pair, but now it's called Patent Center, into here, and you can bring it up. You can see the image file wrapper. You can and you can see where all your your file, your dates are. And the reason why I discuss this is not so much to try to sell the docketing system. That's not our intent. Our intent is we are going to download the rejection, the XML file of the rejection, and automatically parse it out and generate potential response for you. And we'll go, ideally, our goal is to do more than just the usual restatement of the rejection and then just give you a template. That's it. We are actually going to go in there and map one by one the examiner's rejection against the art and then bring all that in. And we're able to do that. However, the system isn't quite smart enough to replace a lawyer yet. So what we're thinking of is, before you start the process, you would have the lawyers give it a hint. Just to say, you'll say, claim one it differs from the prior art because of X, Y, and Z, and they'll take that and they'll generate it out. So that's kind of our current approach is
Hmm.
as a collaborator because the AI isn't smart enough to replace the lawyer yet in responding to a rejection.
Oh, that's very interesting. I mean, I mean, I was wondering about if you I mean, do you work with Fish and Richardson, I'm assuming, and some other law firms? Would you work with the freelancer on this, if I freelance or were to get a job at another company, would you be willing to work with me or maybe like
Oh,
have
absolutely.
yeah.
We have initiatives right now with biotech companies because that's an area that it's very challenging. So yeah, if you're interested, you certainly can become part of our the alpha group where we'll give you early access to some of our early technology, which may not be quite polished enough for commercial,
Sure.
but it's very advanced. And so things like the automated office action response is something that we are working on, and it's going to be, I think the next logical step, right? Because the trend has been that the patent application is kind of restricted to around $7,000 to $8,000,
Mm-hmm.
which gives the lawyers really a fixed amount of time to work on it. And so the AI can fill it in, can help make you more productive that way. But I think your real money maker is in responding to office action rejection because that's something that the inventors really could not.
No, they can't do that. No.
Yeah,
Mm-mm.
that's where the money is, and so that's why we're focusing our attention more on that, a lot of it on that, because that's where it's gonna provide a lot of productivity enhancement to the patent community. And so that's pretty much where we are.
Wow, this is so exciting. Have you heard of a company called Cypher AI?
No, I have not.
They're a British company and they use AI and they do certain things that are somewhat similar to you. Like they use their AI to help develop an abstract. They look at claims and they kind of are summaries of an application. And then they use that summary to find similarity indexes to find other art that's other patent application that are similar in terms of technology area.
I see.
Yeah,
So
classification.
how do you rank us relative to that company?
I like yours more. I think yours is a little bit more. I think you're actually developing the abstract, and I can actually see the abstract. You can't see their abstract. You can only see it develops an abstract. It's confidential. It's inherent to the Cipher AI, but then it comes out with the result. It'll compare it to other patents. It'll say, oh, this application is 30% similar or 40% similar. It gives you some sort of score, but you actually have an abstract that you generate.
Yeah. So I wonder, is that a search company or what?
They do searching. Your scope is a little different. I would say you're actually drafting applications
Oh,
and
well, we haven't shown you the search capability. Let's search in here. We don't charge for that, but well, I guess I deleted your original sample case. So let's take a look at the mechanical case. In the claim,
mhm.
so you see here, there's a search icon. Now,
Yeah.
it's a controversy with attorneys and companies. Some people don't really want to see a search, but if you do want to see a search,
Mhm.
it will map you line by line to the claim, to the search. But you know, we sell that more as a you know, we provide it for free. We don't charge for it because you know, our search is limited to the USPTO data sources, and we're not global. We don't deal with you know, the non NPL basically. But you can see here it's mapping. It's mapping specifically into it.
Oh,
And
that's
so
great.
because we copy from this patent, of course, it's going to be a direct match. So that's why. So it's a good thing that it found its own.
Yeah, right. Good. Yeah, that's a good starting point.
Yeah. So yes, we do have a, we don't call it a prior art search, we call it relevant search. But you know, that's something that's useful for, let's say, if you are in let's say in your role at the aristocrat, if you have an inventor who comes up with an idea, you can help craft the claim, and then you can just send it back to the guy, and then let him look at it, and then let him look at the prior art also. You know, do a search,
Mhm.
and then you know, collaboratively, you can then refine it to you know, to improve the claim. And so this tool can be used by, you know, I typically find most inventors, they are, you're gonna, you know, in a big company, you're gonna have like, let's say 5 or 10 key guys that are repetitive
Mhm.
inventors, right? Those guys are very sophisticated, and they can take this tool like this, and they can give you an invention disclosure that's almost, you know, non-provisional quality. And if you give them the tool to do the art search, and they can tweak the claim a little bit, you can even get an invention disclosure that's practically a provisional ready filing. So that's
Mhm.
our intended use inside of a big company, is to have this tool proliferate to your inventors. They can use it, they can paste in their claims, and then they can do a quick look at this, and then they ship it to you as a lawyer to review. So you basically, you know, have a better life. They do all the
Yeah,
work for you.
right. Yeah, no, I like this. This is very clever, and I really like this. And I don't know, are you looking for any help or anything like that, or any patent agents or anyone? Because this is, I want to be able to use this all the time. This is
Yeah,
very,
yeah, you know, yeah, yeah, it's $4.99 a month. So if you use it once a month, you know, you've more than recover your money, right? So
Mhm.
yeah, we can certainly set it up for you if this is something you like.
Okay. Because I am working with somebody right now, and maybe I think we might. I would like to have I would like to maybe have him on the conversation as well, and
Sure.
maybe we can go from there. I mean, yeah. I mean, I would love to. This is a very I like this, and so you know, I worked in the food area a lot, and in the food area, I think something like this is very helpful. I think something, especially because like the prosecution is very tricky in it. A lot of sometimes the terminology is used interchangeably. The art units are known to be very difficult. It's not as hard as a 3600 art unit, but it's still a very difficult art unit to get things allowed. And I think a lot of the stuff in the food industry, a lot of it goes between trade secret and patent application. So I think this is a way of also generating invention disclosure forms, you know,
Exactly. I mean,
within the
this is
company.
the perfect tool because basically the inventors send you almost everything ready on the plate. All you do is, you know, review it and tighten it up.
Yeah, I think that's what I think this would be a great tool for that kind of industry.
Yeah, yeah, great. Well, we look, yeah, we want to get more, you know, more users like you who you know, are willing to kind of jump over this, I guess, all this fear of AI. But yeah, I mean, you know, you're an early adopter for sure.
Yeah, this was a very impressive demonstration. I really enjoyed seeing this, and if you want me to help work on some stuff, I can certainly help work on some stuff. You know, when it comes to food compositions or mechanical stuff,
Yeah.
certainly, if you want me, I could certainly help out with this. I know you have someone that does some of your biotech work for you. I can't remember his name off the top of my head. I know he went to University of Houston Law School, and then he did the he went to New Zealand for his PhD. So I don't know if you wanted to, if you ever wanted to work with me, I would be happy to work with you.
Yeah, yeah, no, that'd be great. Yeah, yeah, no, it's yeah, you're talking about Kurt Brown. So yeah, no, I think it's in the early days and we can always improve, right? And that's why we work with people like in the biotech, because we know that's a major area where um, we can improve to address that space, because that's a very high end type of patent application, and very specific also.
I think
Uh,
so. It's differently drafted. You have an example section. I think it's more like a scientific paper. That's the way I would always say it. When I was at Beyond Meat, when I work in the food industry, I would tell people that the applications in the composition area are very different than the mechanical applications, not just because of the technology, the way it's written. I think it's written much more like a scientific paper. You have an example section, you have your prophetic language as well. I mean, it's just a lot of like you mentioned, I think it's a little bit more involved, I think, than the
yeah, yeah,
mechanical
yeah. And
applications.
then we also are working with an EPO attorney, because the way we write claims in the US is not what the EPO people like. So
Mhm.
so yeah, so there's a lot of things to solve, and so we're constantly, we're very, very much, happy to find people that wants to modify the product for whatever it is that they're doing. We're, uh, very adapted to that. So yeah, we'll be happy to work with you on that. And all right. So why don't you check with your partner, and then you have my email, and just btran@powerpatent.com, and yeah, we'd love to work with you.
Same here. I would love to work. This is a very exciting program. I mean, I'm not the best with programming. I have some idea, but not really. And this is very interesting and this is very impressive. So thank you very much for taking the time to show this to me.
All right. Well, thanks very much. And I guess we'll talk to you early next year.
Yeah. Hope we'll talk some more and happy New Year if I'm ever in Las Vegas, would you ever want to meet up or something? If you're in
Oh,
Vegas, I'm in Las
vice
Vegas.
versa. You're in Silicon Valley, let's meet up. I actually was down on Sunday in your neck of the wood only over Christmas, and yeah, I just got back about a couple of days ago. So yeah, we're very close.
Oh yeah, absolutely. Hey, I love California. Actually, I'm visiting my mom and dad and my sister in the East Coast right now, so I'm in the New Jersey area. But
Oh,
I'm gonna
yeah,
go
New
back.
Jersey.
I'll be back. I'll be back in the West Coast. I like the West Coast, and would love definitely. If in Las Vegas, I'm trying to actually move to Las Vegas if possible. Like you mentioned, more tax friendly. Not I like California more, but it's just a little bit more tax friendly.
Exactly. Then it's also very pretty there with the access to Zion and Bryce and all that area. So I'm going to CES I guess the next week or the following week. So I'm already mapping out my path to, all areas in Utah, and very pretty.
Oh, yeah, very pretty. And you might find this interesting actually, is that in Los Angeles, there is a guy who's have you heard of Specificio? Have you heard
Yeah,
of
yeah.
Specific?
Specific IO. Yeah, yeah. I know him quite well, actually. Yeah, he's
Yeah,
trying
I
to
worked with some of
do
their
another
stuff
AI,
before.
right?
Yes. I work with them, and Jack Zhu, a patent pal.
Patent. Oh yeah, yeah. He's yeah. I have seen his demo. And yes. I don't know. I don't know personally, but yes, I've seen his videos. Yeah.
Yeah, I use some of his stuff. Very outstanding too. Very good stuff. And so is do you know Bryant Lee? Have you heard of Bryant Lee?
Bryant Lee. What company?
He's in a law firm called Cognition IP. He is about my age, a couple years. I'm 41, so he's like 39 or so. Very talented young man. He went to University of Maryland, did computer science and mathematics, had a perfect GPA. He got into Carnegie Mellon for computer science PhD
Mm,
program.
wow.
Then I guess he got bored with it or something, so he didn't. He went to law school to Harvard, and he worked at Covington as a patent litigation. Then he went into the legal tech, and now he's using AI as well for like natural language processing stuff. And
So is he doing a software company, or is he just more of a user?
software, and he also
Ah,
has a law firm as well. He does a little bit of both,
I see.
and I think his law and he does very impressive guy. And there's another guy named Christopher. I think Johnson. He's a British fella. He moved to from the United Kingdom to San Francisco, and he also does something similar as well.
Hmm.
And with his AI, it's interesting in that it's very software centric,
Mhm.
and it helps identify Alice issues.
Yeah, yeah, we have that as well. I mean, it's, the minute you stick in your tag to say software, then we try to we try to find suggest performance improvement text into it. That's the only known way to solve the Alice issue.
Oh
Mm.
yeah. I mean, I don't know if you heard of this case called McRow. Have you ever heard of McRow? The case McRow.
No, what is it about?
McRow was a case, so it was after Alice got implemented in 2016. There were some cases that, of course, you could argue to get over the Alice hurdle. One of them was NFISH, of course, which implied, like if you soft improves the functioning of the computer. Another one was McRow, where you can say a set of rules leads to a desired result that helps that's directed to the computing arts. So if you have a lot of for example, if then statements or stuff like that, something that can be construed as a game that leads to a result, that could be held as patent eligible.
I've not heard of that, but I've tried, we recently got a rejection and the examiner did not like if then in the claim at all. He said that if you use if then, you had to use some, it was a very open-ended possibility. So he really kind of his reasonable interpretation was so wide, so extreme that I said no, that but and as I argued to him, look, that's an extreme interpretation. He says, oh, but that's because you use if. So the use of if itself in a claim is problematic. So
Sure, sure. But
yeah.
if you could use if you could, I once argued this. I don't know if this is going to work in your case. So I once argued if then statements as a combination that led to a desired result. So that might be a way. And then you can also then argue that if you have 103 rejections, that it leads to an unexpected result or a technical improvement in the computing area.
I think it's probably just examiner dependent, but his position was the if then, and if so, he was arguing that if that condition was false, then all that text behind the then was not considered. You see his point. He
Yeah,
said
right.
it's
But
true, then do X, Y, and Z, and X, Y, and Z was not in the reference. But he took the position that, well, if A isn't true, then all of this is fall through, so therefore it doesn't exist. So therefore, I'm just going to ignore that language after the if condition. So that was his reason.
right, but like I don't know. I mean, like, but you could argue this, like for example, if X then Y, right? But you know that logically, if you say if not X, it doesn't necessarily mean not Y. You know what I mean? Like if X, then Y. Like remember sufficiency and necessity. Like if you are in New York, that means you're in the United States, right?
Right.
But if you're not in New York, it does not mean that you're not in the United States. You could be, and you could still be. It could be in LA. You could be. It doesn't necessarily flow.
Right, but I think the more you complicated the argument, the more you're gonna, you're giving ammo to him to say, well, all of this, and then, So anyway, that's so we have to back off from the if, and we have to rewrite it in a different way to
Yeah,
make
yeah.
him happy. So I think those guys, if they wanted to be troublesome, the use of if, they can not, they can knock it
Yeah.
out. And he cited an MPEP section where it says if you use kind of a language where it's a possibility, they can
Mm.
just ignore the rest of the phrase after the possibility because that possibility may not exist.
I got yeah, right. That's true. Yeah, I know. I've had success at using if then statements in the context of bioinformatics. I've had some success in that area, but that's like more tangible, I guess.
I think it's personal. I mean, I think that guy just happened to have maybe his boss didn't like if then. So
Yeah, yeah.
my gut feeling is, it's not an automatic no against an if, but that's an extra hurdle if they want to take the position that if the
Yeah.
condition is false and that they're not obligated to interpret the rest of the clause. And so that all those limitations you had in the if statement, you just ignore
Mm.
it.
Yeah. I mean,
So
you've
anyway,
probably used DDR, haven't you? You probably used DDR.
yeah.
Yeah, and I don't know what other cases. I don't know. There's probably other cases. I can't think of them off the top of my head. I try to use McRow and NFISH and DDR if I can to overcome the Alice rejections,
So
if
how do you spell
possible.
macro? M little C capital GROW?
MCRO. I put it in the chat. McRow. I put it in the chat.
Okay.
You see it?
Oh, MCRO. Yeah. Oh, I actually remember seeing the thing. Yes. Okay. I'll let me study that a little bit more, but yeah, and see if the use of if then as maybe we'll just put that into one of the alternative claims.
Yeah, yeah, yeah. Or you could say it's like a game or something. Like it's a set of rules. Games are basically if then statements, right? Like if you're playing football, if you're out of bounds, you doesn't you have to give up, the clock stops. There's a bunch of that's what a game basically is. So maybe you can
Interesting.
argue.
Yeah, I personally think it's just examiner dependent. I think
Oh yeah, sure, yeah,
whatever reason he just has this no knee-jerk reaction, and so
yeah,
the best way for me to navigate around it is okay. If you don't like if then, let me restate it somewhere else.
yeah, yeah. Right, right, yeah.
I'm
Is
not
it?
gonna go and fight with him about he's right or wrong.
Yeah, no, that's true. Yeah, is it 3600 art unit or is it a different art unit?
Um, it was the invention was about clean air management. So it's a
Oh,
software that deals with collecting data from sensors to manage the airflow for.
oh, okay. Oh, okay, okay. So
So
it's
I don't
probably
know
not.
whether it was a classified in the air management art unit or was it a software, but essentially it's a SaaS-based software to manage
Mm,
the clean the air the quality of the air in a multi-residential. And so it had contained a lot of these, if the particulate is of a certain number, then you do this and that and that. And so we
mm,
started doing that, sticking that if into there because that was the condition.
mm.
And then we just say, yeah, you know what, all of that, I'm just going to ignore your if, and that's like a third of the claim.
Yeah, no, yeah, yeah, yeah. You just want to make the examiner happy if
Yeah.
that's yeah, yeah.
So anyway, it's good to have yeah once in a while to bounce off some of these frustrations with the examiners, because I just take it in the chin and just say, okay, if you don't like it this way, we'll work it, we'll work extra hard to please you.
Yeah, right. Yeah, exactly. Yes. Sometimes that's the best way to go.
But anyway, well, great talking to you, and enjoy New Jersey, and we'll touch base soon then.
Yeah, absolutely. Thank you very much. Thank you very much for the demonstration, and we'll be in touch. Thank you so much.
All right. Okay. Well, thank you.
Thank you.
Okay. All right. Bye bye.
Okay. Bye-bye.
Thank you for joining our intellectual property education series. We hope that this journey has empowered you with the knowledge to navigate the world of patents, trademarks, trade secrets, and copyrights. Stay inspired, protect your innovations, and continue to explore the boundless possibilities of your inventive mind through the intellectual property system. Subscribe for more insights, and until next time, innovate boldly.